Good afternoon, my name is Felipe. Welcome to my channel Tours in Brazil. Today we're going to continue the studies of international logistics. Book of Donald F. Wood, Anthony Baron, Paul Murphy, Daniel L. Wardlow. If you enjoyed this video, give us a like, share this video with your friends, and start the notifications. Follow me on Twitter, Facebook, Instagram. Don't forget. If you're going to buy at internet, click in the link below, amazon.com and shopping. Thank you very much. Product cost. Obviously, the cost of the product being traded must be covered. There are some legal ramifications to be considered. If the price for an export product is too low, the seller may be accused of dumping. If sales to a country that uses pre-shipment inspections, a price that is too high may be attacked as a method to facilitate hard currency flight from the importation nation. A global firm might have inventories warehoused in a number of different nations. In addition, the products in this warehouse may have been produced in still another set of nations. The seller may assign SKUs, stock keeping units, the same value wherever they are. Otherwise, the value may differ by site of manufacture and site of storage. It is also conceivable that the buyer can take delivery in one of several nations. Both the buyer and seller would have explored which origin destination set results in the lowest import duties and minimize other chains. The second utility of the terms of the sale is on handle the price of the product, however defined, that is most advantageous to both parties. Transport costs. For a sales transaction being negotiated, cost of transportation is addressed by sales terms as well. Products are worthless, or in economic terms, without utility, until they reach the point of consumption, the customer. But who will pay for that transportation? Where is the customer? The Kansas business person exporting to Paris may know where Paris is, but he knows nothing about the French freight transportation system, or freight rates, or even how to go about finding out this information. Consider how difficult international trade would be if exporters were required to have that kind of in-depth, detailed knowledge knowledge of transportation and distribution systems around the world. The converse is also true. The Saudi buyer may wish to purchase from a manufacturer in Lansing, Michigan, or Columbus, Ohio. However, he knows nothing about American transportation. Domestically, sellers deliver their products to their customers' doors. Internationally, that is still generally not the case, although in some markets the practice is getting closer to that norm. As with physical risks, sales terms provide a convenient, internationally recognized shorthand manner for describing the destination to which transportation will be provided by the exporter and who will be responsible for what expense and risk. This is the third utility of international terms of sale. Movement facilitation. The fourth utility of trade terms is in specifying again a shorthand manner who will be responsible for making the various arrangements necessary to move products from one place to another. A good way to describe that process might be movement facilitation. Export-import movements usually involve more than just transportation. They involve clearing customs of the exporting country, entering the customs territory of another, and that, in turn, involves the production and preservation at the proper time and place of various import-export documents of license, permits and various declarations incidental to international trade in merchandise. For example, a buyer in the People's Republic of China (PRC) wishes to purchase a machine containing sophisticated electronic process controls for export in Detroit. The PRC requires all import purchases to be covered by import license in order to obtain foreign exchanges. The US government requires that this type of computer control device be licensed for exportation with validated export license. Who is responsible for what documents? Selling terms. There are two widely acknowledged sets of international sales terms: the revised American Foreign Trade Definitions, 1941, and the Incoterms. The American definitions were promulgated by the U.S. Chamber of Commerce and were last revised in 1941. More up to date with respect to transportation technology and more widely recognized as valid for international transactions are the Incoterms. The Incoterms are the international standard and are therefore the preferred set of these definitions. Before taking a closer look at these definitions, it may be useful to consider that what is being discussed are essential elements of a contract. In fact, what is being reviewed are those aspects of the purchase contract which have internationally recognized aspects. Incoterms are commonly and widely accepted practice and definitions employed by the principals to suit and facilitate their needs and in order to protect their interests. That sounds one-sided, but because both sides feel that use of the terms work to their own advantage, the net result is that both sides are more willing to enter into contracts to sell and move products long distance. On December 11, 1986, the United States ratified the 1980 United Nations Conventions on Contracts for the Sale of Goods. The convention became effective on January 1, 1988, although not all countries ratified it. Its Federal Register notes the U.S. State Department signed to the convention. The convention sets out substantive provisions of law to govern the information of international sales contracts and the rights and obligations of buyer and seller. It will apply to sale contracts